Hello and welcome to Unacademy. Ghooskhor Pandat, a Netflix movie starring Manoj Bajpayee, is in a soup. The Supreme Court has warned the makers of this movie that if they do not change the title of this movie, the court will not let this movie be released. In this video, let's discuss freedom of speech and expression. Why are movies on a slightly different plane as compared to other forms of expression? Does the right of freedom of speech and expression include the right to offend? But first up, how is this topic relevant for the civil services examination? Look at the question on your screen, which was asked once in the mains examination. What do you understand by the concept freedom of speech and expression? Does it cover hate speech also? Why do the films in India stand on a slightly different plane from other forms of expression? Discuss. So let's get started. First up, what is Article 19(1)(a) of Part 3 of the Constitution dealing with fundamental rights? This fundamental right is available only to the citizens of India. Constitution says, no matter which medium you want to use, but you will have freedom of speech and expression. Whether you want to write a song, write a novel, make a movie, enact a play, whatever you want to do, you can do that. That is freedom of speech and expression. But this freedom of speech and expression is not absolute. There are reasonable restrictions imposed by the Constitution itself under Article 19, Clause 2. When the Constitution was enacted, there were only 4 reasonable restrictions. Later on, through various constitutional amendments, 4 more reasonable restrictions got added. The most important case is that of Ramesh Thapar v. State of Madras, 1950. Ramesh Thapar was the founder editor of a magazine, Crossroads. This magazine was banned, its circulation was banned in the state of Madras. Why? Because the government argued that if we allow this magazine to be released, distributed, it will violate public order. Matter went to the court. The Supreme Court was asked, my lord, public order is not a ground on the basis of which freedom of speech and expression can be restricted. Supreme Court upheld the argument of the petitioner and said, no, you cannot ban a magazine on the ground that public order would be violated because public order is not a reasonable restriction on the freedom of speech and expression. And then how Parliament responded? Amended the Constitution. First Constitutional Amendment Act 1951 added public order as a reasonable restriction under Article 19, Clause 2. And it is this public order which is cited by politicians as a reasonable ground or as an excuse or an alibi to take down free speech or dissent in India. Because if you make a movie and it might offend somebody and then they would resort to violence, there will be breakdown of public order, this becomes a potential ground on the basis of which your freedom of speech and expression can be restricted. Let's continue further, but before that, should you wish to prepare with us for the civil services examination, and if you're attempting 2027, now is the best time for you to consider joining our program. Because now our UPSC subscription is available at 17,999. On website, you may see a different subscription fee displayed, but once you use this code IAS English, you will automatically get the lowest subscription fee on UPSC preparation. And should you wish to know more, for 12 months, it's going to be 17,999. For 18 months, 20,999. And if you subscribe to this course for 18 months or more, you are eligible for CSE Assure, which means in your first attempt, if you are somehow unable to crack the civil services examination, your next year's entire CSE preparation will be on Unacademy. So consider joining our courses so that your entire syllabus is completed on time. Let's continue with the discussion. Article 19(1)(a), as I told you, guarantees every citizen of this country the right to freedom of speech and expression. And there is something called incitement standard. Why should speech be restricted? You might be inclined to ask. Imagine this scenario. This is your house, and outside your house there are people who are protesting. This is a peaceful protest. Here is another individual, and what this individual does, he incites them, is telling them, break the barriers, enter, spray or pour kerosene, burn this house down. So what are you doing? Spark in the powder keg. You are, through your speech, inciting people to violence. That is why speech can be criminalized. Because there comes a time when there is no difference between violence and speech, because sometimes speech leads to violence. And that is why courts have, throughout its history, looked into this incitement standard. A speech that contributes incitement to violence, constitutes incitement to violence, or which can endanger public order, that speech can be proscribed and punished. And it is from this freedom of speech and expression that filmmakers draw their power to make movies, to compose songs, to enact plays. But does freedom of speech and expression cover hate speech also? Can you say whatever you want to say and thereby use language, speech, and pulverize, criticize, denigrate a particular member on the basis of his race or religion or caste or language? No. Because freedom of speech and expression is not absolute. And there are, as I told you, 8 reasonable restrictions. You can say whatever you want to say, you can express whatever you want to express, but that is subject to sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, incitement to an offense, morality or decency, defamation, and contempt of court. These are 8 grounds on the basis of which your freedom of speech and expression can be restricted. An important case, Shreya Singhal v. Union of India 2015. Parliament had enacted a section 66 capital A in the Information Technology Act. And remember, this law was enacted in the year 2000, but this section was amended, added to this law in 2008. And when this section was added to this law, there was no debate in the Parliament. Without debate, this section got added to the law, which reminds us the importance of a thorough debate inside the Parliament. Parliament should play its role of a deliberative institution. But be that as it may, this section 66A basically said, if you are saying something using an electronic device, which can be a smartphone, a laptop, a palm top, a desktop, whatever, if you're using any electronic device and you're transmitting messages which cause annoyance to somebody, on this ground, you can be arrested because you are criminal in the eyes of the law. Bala Sahab Thackeray had died in Maharashtra. A bandh was organized by the members of the Shiv Sena. One lady, Shaheen Darda, she wrote on her Facebook page, what is the need to organize the bandh? Her friend liked the status. Both were arrested because they used an electronic device to transmit a message which caused annoyance to the members of the Shiv Sena. Both were arrested. Another businessman from Puducherry was arrested because he posted on Twitter. Now it is X, then it was Twitter, that the finance minister's son has amassed wealth beyond known sources of income, disproportionate wealth. And the then finance minister was Mr. Chidambaram. This businessman was also arrested because you're using an electronic device to transmit a message which causes annoyance to public. But don't you think that truth is always annoying to those who it is spoken to? Law student Shreya Singhal approached the court and asked the court, "My lord, do we have freedom of speech and expression? And if we have freedom of speech and expression, then why is Shaheen Darda arrested? Why this businessman from Puducherry has been arrested? This would violate citizens' freedom of speech and expression." In this case, Supreme Court clarified that no matter what you want to say it. Advocate whatever you want to advocate. Propagate whatever you want to propagate. But the only thing is, don't incite people to violence. If your creative expression, if your freedom of speech and expression leads to violence, we will have to proscribe it. We will have to punish you. Otherwise, say whatever you want to say, express whatever you want to express. Which reminds me, after the assassination of Shrimati Gandhi, and prior to that as well, there used to be slogans raised by some members of a community saying, "Raj karega Khalsa, Khalistan Zindabad." Some individuals were arrested for raising these slogans. Matter went to the court. Supreme Court said, slogans, no matter how much inflammatory they are, unless and until they lead to violence, this is a protected free speech. Constitutional expert Gautam Bhatia argues that free speech protects dissent. That is how we can criticize the government. That is how we can show mirror to those in power. But the only thing is, you should not be inciting people to violence, because hate speech also does not come under the shield of the free speech. Don't incite people to violence, and don't use a speech or an expression through which you are denigrating a community based on its race or language or religion or gender. Because then you are propagating hate in the society. Now listen to me carefully. You want to write a novel, or you want to publish a newspaper. Although freedom of press is not explicitly mentioned in the Constitution, but the Supreme Court has said freedom of press is also a fundamental right under Article 19(1)(a) of the Constitution. But do these newspapers need to take consent of the government before they publish newspapers? Do they have to get the editorials and columns vetted, approved by the government of the day, and then these can be published in the newspapers? No. Because if that happens, that is censorship. And this used to happen during the emergency. When emergency was imposed in 1975, newspapers needed to be vetted by the government of the day. Only after that, these could be published. And that is what we call censorship. But there is some sort of censorship in movies. Can you make a movie and display it without getting the approval of the CBFC, Central Board for Film Certification? No. Matter went to the court. K.A. Abbas v. Union of India, 1971. My lord, if we use other forms of creative expression, there we don't have to seek prior approval. There we don't have to seek the approval of the government. Why is it that you are discriminating against the movies? That when we make movie, we can't screen these movies, display them, exhibit them unless and until there is approval by the government-backed CBFC. Supreme Court justified this. Supreme Court said movies are different from any other forms of creative expression. How are movies different? Imagine it this way. You're reading a novel, and then on the basis of this novel, there is a movie made. Which will arouse more passion in you? A movie or a book? Possibly a movie. Why? Because movies They mix the acting of an actors together with background music, and this combination, dramatic acting, lights, background music, performance, this stirs emotions than any other form of creative expression. It creates a strong audio visual impact, and it has a greater potential to disturb public order. That is why movies cannot be screened unless and until they are certified by Central Board for Film Certification. But once CBFC issues a certificate, after issuing the certificate, can you block the release of a movie? Saying if we release this movie, there is going to be disturbance and violation of the public order? No. Who says this? Supreme Court in Prakash Jha Productions v Union of India 2011. Once the CBFC certifies a film, the state governments cannot suspend its exhibition just because you apprehend violation of public order. Because it is the responsibility of the governments to protect, uphold public order. This would happen when movie Padmavati was released or was about to be released. A member of a community or a community itself decided that this movie is against our beliefs, against the Rajputs, for example. They started violating public order, and ultimately the filmmaker had to succumb to the pressure and change the title of this movie from Padmavati to Padmavat. Similar to what happened last year, Janaki v State of Kerala. The regional center of the CBFC, because CBFC has regional centers where these movies are screened and then approved. The regional center of the CBFC cleared this movie. But then the CBFC objected to it, saying no. Why? Janaki is one of the names of Sita, goddess Sita. And here in this movie, she is shown as subjected to rape, Janaki. On this ground, the CBFC said that we assume or presume that there will be hurt feelings. Sentiments of the people will be hurt when they will watch this movie. Particularly the cross-examination of the protagonist inside the court by a lawyer belonging to a different community. This movie's release got delayed. But the point is, Janaki is one of the names of goddess Sita. And it is one of the most popular names amongst women. And even those with the name Janaki, they suffer various atrocities in their life. Movies are the reflections of the society. Movies show society its mirror. And if there are individuals who are facing hardships, those should be shown in the movies. And finally, what the filmmakers did, they altered the title of this movie, Janaki V, instead of Janaki V State of Kerala. And one of the scenes in this movie was also muted. I was talking about when Janaki is cross-examined by a lawyer belonging to a different faith. And this is not the only time. In 2017, CBFC objected to the word sexy in the title Sexy Durga. And the producers were forced to alter the title and call it S. Durga. This, according to various writers, activists, this amounts to chilling effect on the art, on the production. How? I'm going to tell you slightly later. Noted expert, political scientist, one of India's most brilliant minds, Pratap Banu Mehta, he argues that Indian democracy faces tyranny of herd sentiments. State and society, they collude and they suppress dissent. And this is where we need the role of an active judiciary to uphold free speech. and only come down heavily if this free speech is resorting to violence, is inciting people to violence, or is leading to hate speech. Otherwise, you should let every single creative expression flourish. That's what Voltaire also said. I disagree with you, but I will defend till death your right to say it. Disagreement is health in a society. Dissent is a health of the society. We may not always agree with each other. Gautam Bhatia says, now there is something called heckler's veto or mob veto, which is inconsistent with Article 19, Clause 2. You do not agree with a movie, don't watch it. You do not agree with a movie, write a critical review. You do not agree with a movie, make a different movie on the same subject. But you can't stop others from watching that movie. You can't let the ideas wilt. But in India, what is happening? Some people say that we are not Hindustan, we are Banistan. We don't agree with a movie or a song or a book, we ban it. And just because there will be a mob with stones in their hands and they will try and disrupt public order, we block the screening of movies, block the release of books. And that is how Satanic Verses was banned by the government led by Rajiv Gandhi, because it might have offended the members of a particular community. But be that as it may, look at these passages. When Ghoskhor Pandat, this trailer was released on YouTube by the Netflix, it was the Chief Minister of UP who directed that FIR be filed against the filmmakers. Why? Because members of the Brahmin community, the Pandit community, they are offended by this, calling them Ghuskhor. In a diverse society such as India, people can plausibly say they are hurt by many things. And that is precisely the reason sentiments are not the useful thresholds to trigger a criminal process. Your sentiments are hurt. For example, the question I was asking, does right to freedom of speech and expression include right to offend? Yes. The only restriction is you should not incite people to violence. For example, if tomorrow the members of the Dalit community make a movie, or anyone makes a movie which shows the kind of caste atrocities committed against them by the members of the Brahmin community, by the upper castes, are you offending the upper caste? Yes. But do you have the freedom to do that? Yes, but without inciting people to violence. Can a particular community say, my sentiments have been hurt? No. Why? Because that is not a reasonable restriction. Your freedom of speech and expression can be restricted, as I told you, on 8 reasonable grounds, and sentiment is not one such ground on the basis of which your freedom of speech and expression can be restricted. But then what did the makers of the Ghoskhor Pandat do? They deleted that marketing campaign. They removed the trailer from YouTube. And this has been also criticized. Because when the filmmakers and distributors, they believe that the safest way out is to erase this contested material, we will erase it. Then do you know what is happening? Public lose access to this art form. Courts lose the opportunity to lay down a legal rule whether this should have been done or should not have been done, whether Ghoskhor Pandit violates or does not violate free speech. Society lose their chance to exercise a democratic response to this controversy. People should have the right to boycott this movie or manufacture satire in response to it. But you don't want to do this. You want to erase this material from social media. This is what leads to chilling effect. And the marketplace of ideas wilt. Because tomorrow another filmmaker in a different corner in India would also erase the literature he was writing, because he will be forced to do that, because he will assume or presume that if he makes out this movie, he's also going to face the same wrath. Some say everybody has freedom of speech and expression. You can say whatever you want to say. There should be freedom after speech as well. Not just freedom of speech and expression, freedom after speech as well. Speech is not always without consequences, free of consequences. There may be consequences, but it is for the state to protect free speech if it is legal, justified, and does not violate the limits, reasonable restrictions imposed by the Constitution. But if the Chief Minister of a state, without following the due process, directs the FIR or the filing of the FIR, it sends a chilling effect down the spine of the upcoming artists. And the principal loser would be the creative individuals, the artists in India. How should the courts balance free speech and at the same time ensure that this free speech does not lead to hate speech or violence against communities? Do let me know in the comment section. And if you haven't yet, subscribe to our channel now.